anything that grows is considered as a living organism. And the same happens with the Constitution of India. Constitution of India is called a living document. Now you might ask us, why do we call it as living? It's not growing. But the thing is, when we are doing amendments, when we are doing changes, it is actually making the document live. It is updated and with the needs of the current society, current generation. All changes that are required could be made in the constitution, and therefore we consider constitution as a living document. So this was just a very quick, precise summary. Over this lecture we would understand how this actually happens. So the first thing is, it can be given as a living document. Why? Because there can be amendments that can be done in the constitution. These amendments make the constitution lively. Once the amendments are done, the basic structure of the constitution remains the same. So as a child, when there is a child, you would see the basic structure or the format of the child remains the same, but as the child grows, there are more things that come into play. The same happens with the constitution. The basic structure remains the same and it grows over the basic structure, right? And in this process, who plays a major role? Judiciary plays a major role. And based on this, the document is constantly evolving, constantly responding to changes. And this is what we would understand in this lecture. So the first question that comes into our mind is, are all the constitutions globally static, or it's just the Indian constitution which is a living constitution? Now definitely each country have its own constitution. India has adopted the constitution ideas from variety of countries. If we talk about countries like Soviet Union, we'll take some of the classic examples here. Soviet Union had its constitution in 1918. It had its constitution again in 1924, 36, then 77, and then finally after the collapse of Soviet Union and formation of Russia, the new constitution was adopted in 1993. So there have been numerous instances where the constitution has been changed. So this was one example from Soviet Union. Let me pick up another example from France. Now France, post the 1793 revolution, which was known as the First French Republic, there was the commencement of the Second French Republic in 1848, the Third French Republic in 1875, and since the 1946, the new constitution came into existence from France. Now, this is another important aspect that we need to understand. India got its independence in 1947, had its written constitution from 1950, 26th of January, which is celebrated as the Republic Day. Now, one of the interesting things to note about United States is the Constitution of United States is more than 200 years old, but so far only 27 amendments, or it has been amended only 27 times. What does that indicate? This indicates a clear picture that the people who had written the constitution for United States had a greater foresight. They were able to understand what could be the need of the hour and how could the changes need to be reflected in the present scenario. So the next question that comes into mind is, now we have seen that the constitutions are not static. Even for countries like Soviet Union, France, we have seen numerous constitutions coming into play. For countries like United States, where there was just one constitution, we have seen series of amendments for it. Now, the next question is, if it is just one constitution like United States, how does it continue to work seamlessly? Our constitution, similar to the United States constitution, considers the fact that there is necessity for modifications wherever required. But these modifications need to be balanced. They neither need to be very, very simple so that anyone can come and amend, or they need not to be too rigid so that even the common man or the members of the parliament find it very difficult to change the existing scenario. So modifications are there, but those have to be rationalized based on the changing needs of the society. So based on the changing needs of the society, these modification needs to be taken into account. The next is the flexibility in interpretation. So how do we interpret the constitution? That's again an important aspect. As we know, Indian constitution is rigid as well as flexible. Now when I say rigid as well as flexible, that means there are some parts of the constitution where the changes could be made easily, but there are other elements in the constitution where the rigidity is to be maintained. So political parties' judicial rulings show how mature and flexible implementation should be there into account. The next is, how do we tackle the problems of the society? The provisions of the constitution help us to take into account how do we actually handle the social situations. So how do we handle the social aspects or the social issues in the society? Understand that this constitution that we have is not a frozen document, right? It is through the effort of us that there have been constant revisions, constant changes, constant new things which are added after examination, re-examination, and this is what is called as amendments, or the changes in the constitutions are brought. So amendment is an important integral part of our analysis. The next important thing that we need to understand is the constitution also reflects the dreams and the aspirations of the society of the common people. Now you might ask me a question that if we want to bring a change into a society, into the constitution, we as a common people cannot do. Who has the right to it? The right is held by the members of the parliament, the members of the state legislature in the case of special majority, as we'll understand later. Then, how do you say that we as a society have the right to modify? We as a society have the right to modify for the only reason that we are the ones who have elected the members of the parliament, who have elected the members of the state legislature. That means they are representing the common people. So ultimately, if there is any amendment that is brought that is representative of the society or a larger part of the society, that simply implies that society has certain opinion about certain thing, and that opinion has to be brought into consideration. And under Article 368, Parliament exercises a special constituent power to amend by either adding a new content, creating a variation in the existing content, or repealing the content, right? And that's something that must be taken into account. The next is, how should be the constitution? Now this is a very interesting question. As I said, our constitution is flexible, but at the same time it is rigid. What does that mean? We maintain a fine balance between flexibility and rigidity. Sometimes the constitution has to be rigid because the rules should not be so simple that any new party comes into play, the constitution rules are changed. Or it should not be so flexible that there is no importance given to the core concept, right? So there are various things that we take into account. When we talk about constitution and its amendment, there are three ways into which it can be amended. One is by simple majority. Now this happens for most of the basic cases. For example, Parliament may add an area or a new state under Article 2. That's under simple majority. Under Article 3, Parliament can increase the area of any state. That's again under simple majority. Then comes a special majority into play. And then the third case is a special case of special majority, where 1/3 of the member present in voting along with 50% of the members of state legislatures who are also contributing to it. So two cases of special majority are taken into account, right? So, Article 368, as we have discussed, talked about the provisions of special majority, and a special majority with role of state legislatures usually seen when we are talking about the federal structure or the federal setup, where we have the involvement of the states, that is crucial, right? Again, important thing. Now, an amendment bill, like all other bill, goes to the president for the consent, but President, in the case of an amendment bill, has no power to send it back for reconsideration. And this makes the constitution rigid and complicated, right? Because it's not as simple as for the other changes in the rules. If there is any amendment in the constitution and it goes to the president cannot send it back for reconsideration. That means only the elected representatives have a say, and those elected representatives represent the majority of the population who has voted for them, and this forms the basis for the amendment. And this was in the words of B.R. Ambedkar, who said that the constitution needs to be examined and re-examined from the eyes of the common people, right? Now, the next thing is, as I mentioned, special majority. So what includes a special majority? Now, there are two components of it. One is half of the members must vote. So half of the members must vote. That's the first thing. And the second is 2/3 who have taken part in the voting must vote in favor of it. That means, let's say there are 545 members. Of this, half of the members, that is nearly 273 members, must vote. And of the total members, let's say there are 300, of that 200 members must vote in favor of it. That makes sure that there is a special segment, or it is being represented by a greater majority. So, in what cases the constitutional amendments would actually take place? The constitution amendments would actually take place when there is a strong majority. That's one thing. Or there is a coalition government, right? Now, the rules for the special majority also vary. In the case of United States, similar to India, it is two-thirds of the majority. In the case of South Africa, in the case of Russia, it is 3/4 of the majority which is required. So rules again change based on country. What we are discussing right now is from an Indian constitution perspective. Now, there are other countries, for example, Russia, Italy, Switzerland. Here, even common man can come forward or take an initiative for the process of amendment. What does that imply? That if I feel a given law is not working appropriately, it needs to be changed, I as a common man can initiate this amendment. But this does not hold true in India. It holds true in countries like Switzerland, Italy, Russia are some of those which have been cited. Another important thing in the case of a special majority is that the sessions of the parliament are not conducted as a joint session. What does that mean? Individually from Lok Sabha as well as from Rajya Sabha, both these conditions must be fulfilled. Clear? So, half of the members must vote and two-thirds of the members present must vote in favor of it. And that should be the condition which should be met individually both in Lok Sabha and Rajya Sabha and not as a joint sitting. The next is ratification by the states. Under ratification by the states, as I discussed, this is a case of a special majority with 50% of the members of state legislature voting for it. Now 50% of the members of state legislature voting for it indicate that these matters are the matters that talk about distribution of power between state and center. So it talks about distribution of power between the states and the center, and states must be consulted and states must give their consent in order to have this done. And therefore, this is a special case of special majority where 50% along with the two criteria of special majority, there is a third criteria which says 50% of the members of state legislature must vote for it. And this implies mainly in accordance to the federal structure of the country, the distribution of power between the state and the center, where the consent of the state is important. The next is, why don't we have just one amendment? Why there are so series of amendment? So in 2006, if we talk about from 1950 to 2006, 26 January to 26 January, we have seen in those 56 years of existence that we have, there were nearly 93 times amendments which were done in the constitution. Of this, the highest number of amendments were done between 1970 to 1990. Two special episodes of amendments, one from 1974 to 1976 and other from 2001 to 2003. The amendments from 1974 to 76 was a period that incorporated the emergency provisions, and this was a time where the predominant reason was a Congress dominated structure, and the Congress had a huge majority. As a result, the amendments were easily passed. Clear? You need to have 50% of the strength and 2/3 of the members present and voting, and that special majority could be fulfilled because it was predominantly a period of Congress domination. The next was from 2001 to 2003, and this was because of a different reason. It was not because of a domination of one party, but this was because of the coalition government during this time. Now, since it was a coalition government, you had different political parties who were in power, and as a result, there was also rivalry between BJP and the opponents, which was one of the reasons that this amendment actually took place. The next important aspect that we would understand is the content of the amendment that have been made. Three aspects. One is the legal or the technical aspect. In this, I talk about simple things. For example, increasing the age of retirement from 60 to 62 for High Court judges. I can say salaries of the judges to be increased according to the Amendment Act. So, there are various Amendment Acts. For example, increasing the age was under 52nd Amendment Act. Increasing the salaries was under 55th Amendment Act. Similarly, the reservation for the SC/STs was initially 10 years. However, it was later increased to 10 more years, and that was through a series of 5 different amendments. So, these are legal or technical aspects. The next is based on different interpretations. So, based on different interpretations, what can be taken into account? Based on different interpretations, we have important aspects that are taken into account. For example, conflict between fundamental right and directive principles of state policy. That's one. The second is the power to amend the constitution. The third is the right to property. So those are all under the aspect of different interpretations. What does that mean? That means that there are different interpretations which are given by the constitutions or by the judiciary, and therefore this needs to be taken into account. The next is the amendment through a political consensus. So when I talk about political consensus, what does it imply? It is mainly in the case of Anti-Defection Act. So, anti-defection under the 52nd Amendment Act is important. Then under the 73rd Amendment Act, 74th Amendment Act, the rural and the urban boundaries, those are all under the political consensus. Besides the 3 ways under which amendments can be made, there can be chances of controversial amendments. Now, when I talk about controversial amendments, it's the Keshav Nandan Bharti case, which is the most cited one amongst these. So, the 42nd Amendment was considered as one of the major amendments which was brought in time immediately post the emergency period. So it had huge number of amendments which were brought. Some of the amendments were basically extending the tenure of Lok Sabha from 5 years to 6 years, inclusion of fundamental duties, restrictions on the review of the power of judiciary, and there were numerous such amendments which were brought. However, the later government in the 43rd and 44th amendment rolled back a lot of them, and as a result what happened was there was an important change that was marked, and therefore 42nd amendment itself is considered as a controversial amendment in the Indian Constitution. So three important aspects, I repeat again, based on technical and legal, different interpretations and political consensus. The next important thing that we need to understand is the structure and the evolution of the Constitution. Now, Keshav Nandan Bharati's ruling has been brought about in some specific ways. First, it has set the specific limit of the Parliament's power to amend the Constitution. So, power to amend the Constitution is one. The second is it has placed judiciary as the final authority. So, judiciary as a final authority in order to decide how the ruling should be done. There can be no amendment which can violate the basic structure. So, no violation of the basic structure of the Constitution can be done. Those are some of the important takeaways of Keshav Nandan Bharati's case. Clear? Now, what is important when we talk about the structure and the evolution? Since 1973, the court has many cases which have been elaborated on the basic theory. However, there have been the basic doctrines which have been contrasted based on the rigidity and flexibility. Clear? If we take the same example, in the year 2000, it was Justice Venkatachalya who was appointed to review the working of the Constitution, and it stuck to a basic theory that the basic structure of the Constitution cannot be violated, and it did not suggest any measures which would endanger the basic structure of the Constitution per se. So that is one of the important aspects. Now, Supreme Court has taken numerous instances. For example, Supreme Court has talked about reservation in jobs, reservation in educational institutions. All of those indicate what? It indicates the importance of judiciary in the system. Also, there have been a case talking about the creamy layer, which was decided again by the Supreme Court. There have been various provisions related to right to education, right to liberty, managing the minority educational institutions in some of the other cases. Because of all the things that we have discussed, Constitution, as we started in our very beginning of the session, is called as living document because it responds to our experiences that happen. That means that if we feel that these things are not correct, they need to be modified. There are set amendments which are brought, and the Constitution can be modified according to the amendment. So, Constitution continues to work efficiently. It has the ability to remain dynamic. It is open to interpretation. It has the responsibility to change to the changing situations, and this is what is called as the hallmark of democracy. So I can say it is the hallmark of democracy because it maintains that any change which is there can be brought into account. So a constitution actually protects our democracy. Not only it protects the democracy, but it allows evolution of new practices. Right? New practices become not only durable, but they also respond to the respect from the citizens. And that's one of the major reasons we say that it is being a living document is an hallmark of the democracy, because democracy is not just about vote. It is more about people's participation. And here, under a special majority, people cannot participate directly, but indirectly they do participate, and therefore it is considered as a living document. The next is, in the same process, there is an important role that judiciary plays. As we said, that constitution, through the parliament, what happens? Through the parliament, there is power and responsibility to make laws, amendments, right? To make sure the interests of poor are protected. There is backward and needy classes which are taken into consideration. However, what does judiciary do? Judiciary says that these priorities are not given arbitrarily, or there is no arbitrary use of power. Arbitrary use of power must be checked. And who checks this? Definitely it's the judiciary who checks it. So parliament frames the laws, amends it, makes sure that the poor, the needy, the backward gets the right of it. But who checks that the power is not used arbitrarily? It's the judiciary that checks that power is not used arbitrarily. Now, again, the court came to a conclusion in reading the text of the document. So it's not just the text, right, or the letter, but it is the spirit of the constitution that is important. So the idea is not just to read the text or to read the letter, but the spirit of the constitution must be maintained, and judiciary makes it sure that this is maintained clearly. And when we talk about the maturity of the political leadership, Keshav Nandan Bharti case is a classic example, because there were attempts that were made to ask the court to reconsider the rulings which were done. However, when these failed, the 42nd amendment was made, and this was one of the major amendments, as I previously mentioned, in the history of the parliament, which asserted that there has to be a basic structure, and parliament accepted the idea of a inviolable basic structure. So the idea of a inviolable basic structure was adopted under this ruling. So based on this, the whole thing that we have discussed for this lecture, we can understand that how a living document is an important constituent of the citizens' participation. It's not just about, politics is not just about vote bank, but it is about people's participation and people's representation. And this people's participation and representation is seen even when we are amending our rule book, which is the constitution. The amendments of the constitution are passed through special majority. The members who pass the special majority are actually the representative of the common people. And also we have talked about the three contents of the amendment, which is based on the legal or the technical aspect, the differing interpretations, and based on the political consensus. So if one political party is in predominance, that political party would have a consensus and the amendments would be passed easily. So those are some of the important things, and later definitely the detailed political science sections, if you want to cover, we have covered Lakshmikant, D.D. Basu, Subhash Kashyap and other references in our elaborate lectures on political science for UPSC. The detailed link for those are available in the description below. So do follow those. Have a wonderful day ahead.